Welcome back to Courtroom Authority. Today's case is a classic showdown between a landlord and tenant, and let me tell you, it's about to get messy. We've got bounced checks, unpaid rent, and a tenant fighting to keep her home right before Christmas. On one side, riverside townhouses backed by attorneys and management. On the other, Catherine Yoder, a tenant claiming hardship, mental health struggles, and housing issues. But here's the twist. The rent balance keeps changing, payments are late, and at one point, a check was written from a closed account, which is not just a financial slip-up, it's actually a criminal offense in many states. Judges don't take that lightly. So the big question is, will the court give her another chance or move forward with eviction? Stick with us. This hearing is packed with emotional pleas, legal arguments, and a decision that could change everything for the tenant's future housing. What would you do if you were the judge? Let's dive in.
You had two opportunities to be here. You did not appear. You presented a check for payment, which was on a closed account, so the payment wasn't made. And to further put salt in the wound, your current rent is zero. Thank you for joining us on short notice. I'll try to recap the history of this case as I understand it. The title of it is Riverside Townhouses versus Catherine Yoder. Catherine Yoder is here by Zoom. Laurie Kalmbach, the manager at Riverside, is here. Meg Bauer is here from Legal Aid, and Carrie Zanin is here on behalf of the Cox Law Firm. They're very busy. We did call and clear the state to see if they would have somebody available, and apparently Ms. Zanin drew the short straw. So here she is. So let's back up. The plaintiff sued for black rent in a non-payment of rent case. At the time the matter was filed in September, the arrearage was $1,186. Now, we just had a previous case, 241208 LT, dismissed in August. So by the time of September, she's now alleged to be $1,800 in arrears. So she was personally served with a complaint, and we had a hearing on November 15th. And let me look at the signed copy. The defendant, here it is. That was on November 15th. The amount of rent was $718, $184.47, and for a total of $902.47 due by November 25th, or the defendant was subject to eviction. As I indicated, she was personally served. She did not appear. We got an email from the defendant on December 4th. In point of fact, if plaintiff had sought the eviction before that. But anyway, it wasn't a formal pleading, it was an email. So it doesn't have anybody's heading on it. She didn't pay a filing fee. She simply sent an email, didn't give service to the plaintiff, and said, I respectfully request that the default judgment entered against me be set aside. I was unable to make rent payments for the month in question because I was not working during that month due to challenges. I live in an income-based apartment and technically should not have been required to pay rent during those months. As I indicated, we just resolved another case of the same tenancy in August. I understand the importance of meeting financial obligations and other important meetings such as the scheduled court dates that I failed to attend. I did not attend to avoid my responsibilities. Fortunately, due to my mental health challenge, I was unable to respond to the lawsuit in a timely manner. I asked for the opportunity to present my case fully and discuss a fair resolution, including the possibility of payment arrangements. I am committed to resolving this matter and sincerely request the court's consideration to set aside the default judgment. So we treated it, even though it was just an email, without notice to the other party, and I set this emergency hearing. As a general rule, when a party moves to set aside a default, they have to show, they're supposed to file a meritorious, an affidavit of a meritorious defense and show good cause for why they didn't show up. The defendant had shown up for hearings in August. She was personally served. She didn't show up for this one. She makes some veiled reference to the fact that she had mental health issues. I'm not sure that rises to a legitimate reason for failing to appear. And a meritorious defense, her defense, I guess, is that somehow her rent should not have been set in this amount. As I indicated, we just dismissed the other case in mid-August. She had apparently paid some rent because the claim was for more than what the judgment actually entered. So we asked the Cox Law Firm to be here. We forwarded a copy of the defendant's email to them, and Attorney Carrie Zanin is here. Ms. Zanin, what's the plaintiff's position?
Well, Judge, I was going to argue the court rule. I don't believe that good cause was, well, first, I don't think we even need to get to the good cause and the meritorious defense, as this motion should have been filed within 10 days. And motion, email, the judgment was signed on the 15th, 10 days would have been the 25th. She's an additional 9 days beyond that date. I don't believe she's, in compliance with the court rules as to the time frame. And I don't believe she's delineated good cause to set aside. She was personally served. She had the court date. She didn't appear. And I don't believe there's a meritorious defense either. As to your questions about the August, I can tell you by looking at the ledger, she did make a payment late in August that brought her balance down to $70, and that's probably why the dismissal. And then, of course, September, October, November, and December are now due. So I would ask that you deny the motion.
So is it your position that once she made the August payment, that no payment was made for September, October, November, or December?
No, Judge, her balance actually right now is $923. So there's been small payments made since the date of the judgment. The only payment that shows is the utility reimbursement. So I apologize. But what I'm showing at this point with December is that she owes $923. So an extra $20, Judge, on the judgment.
All right. Now, sometimes there are a couple things. When you fail to appear in a landlord-tenant case, you have 10 days to appeal. And you didn't file anything within 10 days. You filed it on December 4th, which is 19 days after the judgment entered. Now, theoretically, on a motion to set aside default, you have 21 days to move to set the default aside. But that's in a money judgment. This was a landlord-tenant judgment for possession. So there are multiple issues. One, there's no meritorious, well, it's multiple. You didn't properly file it. It was filed more than 10 days after the appeal period. It wasn't served on the other party. We served it. You didn't file an affidavit of meritorious defense. And I'm not sure there is a meritorious defense. You simply owe the rent. Somehow it's your contention that it shouldn't have been calculated as this, but we just had another case about 3 weeks before it. And you're employed now and working somewhere in what looks like a good job. So they want to stand by the original order that's now 923. So what are you seeking at this point, Ms. Zanin? An opportunity for her to pay the rent or a writ of eviction?
I believe we are asking for a writ of eviction based on the judgment that was signed on November 15th, 2024.
All right. Ms. Yoder, what's your position?
I'm wondering, what job do you feel that I have? I've been
Well, you
unemployed
said
since
you were
July.
out of state as at a conference.
That is not
So
related to work, Your Honor.
oh, okay. I thought it was
And
a
I've been
work.
unemployed since July 25th. And the reason why I've not, she's giving me the 528 rent fee for August is because I neglected to let her know that I quit my job at Gemstone Solid Surfacing in Elkhart, Indiana, July 25th. So she's putting that 528 for rent in August. And then the extra fees are the court fees for the missed court hearings that I missed. So how am I supposed to pay for that with no job? Plus, I've had interviews. I've applied for over 30 jobs remotely and out of in the workforce, and I've not been able to get hired. For that reason, I really don't know, other than the fact that I've been trying to do my best.
Well, I respect that, but none of that's a defense of the fact that you haven't paid your rent. Now, Ms. Kalmbach, could you unmute? She says she quit her job. Did she ever notify management or ask for a recertification?
She did, and that's why she owes the August rent, because she did come in and we did take her down to 0.
All right, so she owes August rent, but she's 0 currently.
Yes, September 1st, she went down to 0 rent.
All right, so how do we get 923?
Let me look at her ledger. She had some non-sufficient funds because she wrote us a check on a closed bank account.
Well, she had told us she didn't raise any of this. She said she was going to pay it. And then some checks bounced. And let me back up. We were here on November 4th. She wasn't here. On November 4th, another attorney from Cox Law Firm, Jen Wilburn, was here, and Ms. Kalmbach was here. Defendant had brought in a check. She was nervous about it. She wasn't sure it would clear. The arrearage was $658, and that was through November, and it was $184.47. So it didn't include, she brought in a $658 check, but did not include legal fees. So she missed the first hearing on November 4th, but because the check had come, I waited to see if it cleared. I continued it to November 15th. Ms. Kalmbach indicated that the check had bounced and did not clear. The defendant did not appear, and I issued the default judgment. 718, 184.47, and 902.47 total. The check came back as account closed, which actually is a misdemeanor. And so the check didn't clear, the account was closed, the defendant didn't appear, she didn't file anything within 10 days, and the plaintiff still wants her to move out. All right. So,
Your Honor, could I add something else?
yes.
Back in July or August, I believe, the landlord came in to check my ceilings, and she had said that she was going to come get them fixed. And when you look at my ceilings, I can provide photo evidence as well if you need that. It's bowing down. And there's been 2 other tenants that I know of personally whose ceilings have caved in and fell.
Stop. The time to raise that defense was at the time of the hearing. We were all here. Now you haven't paid the rent. You didn't file it in a timely manner. You didn't file it properly. You didn't file an affidavit of meritorious defense. And now you're raising some habitability issue that you had 2 opportunities on November 4th and November 15th to raise. So I adjourned it because you had presented a check Not only did it bounce, the account it was written on was closed. So payment wasn't received, then you didn't appear on the 15th. Ms. Kalmbach or Ms. Cox, do you have any interest in allowing her an opportunity to pay the unpaid rent or simply ask for a writ of eviction?
I think at this time, Judge, we're asking for the writ of eviction.
I don't believe I've received it yet. Let me look.
I would rather pay the 528, meet you in the middle with that. I'm going to have to get some help, but I would be glad to do that because I don't have anywhere to move to right now.
Yeah, I do have the writ of, they don't want you to do that. I did get the writ of restitution eviction on December 9th. The motion to set aside the default is denied. It's outside of the 10-day appeal period, even if it was considered that it was filed within 28 days. There's no good cause shown for failure to appear, and there's no affidavit of meritorious defense. They don't want you as a tenant anymore, and it's going to show as an eviction on your record, which may make it very hard for you to get into any other subsidized complex. They don't, theoretically, this order will allow them to evict you tomorrow or Monday morning, but maybe they can work out some sort of accommodation or agreement. But I will sign the writ of eviction. So you're in a difficult spot. It's right before Christmas. You had two opportunities to be here. You did not appear. You presented a check for payment, which was on a closed account, so the payment wasn't made. And to further put salt in the wound, your current rent is zero. You're not going to be able to find rent for zero. So my suggestion is that you go in and meet with the manager and see what you can work out for a move out date. They don't have to serve this order for 56 days. But they can serve it immediately. That's been held since December 9th, and today is December 13th.
Can I at least get my things packed up and in a U-Haul so they're not
Yes, I'm sure
putting
they'll
my
agree
things
with-
out in the street?
It's a lot easier to have you do it than have the sheriff do it. So I'm sure they'll work with you regarding that. All right. Like I said, I don't have to like it. I have to follow the law. All right. That completes this record.
Thank you, Judge.
And there it is. The judge has denied the motion to set aside the eviction. Catherine Yoder is officially out, and this decision will stay on her record, making it nearly impossible to secure another subsidized apartment in the future. The court made it clear. Missed hearings, bounced checks, and failure to follow legal deadlines all come with serious consequences. This case is a powerful reminder of how fast things can spiral when rent goes unpaid and court dates are ignored. The judge showed some compassion, giving Catherine time to pack and move her belongings, but legally, his hands were tied. What do you think? Should the court have shown more leniency given her situation, or was this the only fair outcome? Drop your thoughts in the comments. We want to hear from you. And if you found this breakdown as intense as we did, don't forget to like this video, share it with others, and hit that subscribe button so you never miss another dramatic courtroom moment right here on Courtroom Authority.